Hunter Biden's prosecutors reject his claim. We know that his lawyers said, no, we've already got immunity. We already executed the diversion deal. It's in full force and effect. Hunter is immune from everything, including the special counsel inquiry, because the immunity covered all of the conduct from Hunter's prior years. And this emerged after a very interesting battle that took place in court. We know the Biden DOJ, as corrupt as can be, created this rigged deal with Hunter and the DOJ so that he could get basically everything dismissed and blanket broad immunity. The court rejected the plea deal, but Hunter's lawyers told the court to get bent, to pound sand, and basically to F off, and said, hey, you, judge, you don't get to come and interfere in a private deal, in a private diversion agreement between the United States and our client, Hunty, and it's done. So they told the judge, the defendant, Hunter, and his counsel wish to thank the court for its attention to this case, which is attorney speak for get out of here, right? To get bent. You're done, judge. You have no jurisdiction over this. This is a private agreement between the defense and the government. But unfortunately for the defense, doesn't seem like the government agrees with their take. They say the diversion agreement was already created and in effect. The government says not. Here's what they filed. 7 pages out of the District of Delaware with our very estimable judge, Judge Norica, who didn't take guff from these people. Says in the United States of America versus Robert Hunter Biden, the United States is now replying in support of its motion to vacate the court's briefing order. So the Hunter's attorneys said, judge, we're done with this case. Thanks for being here. And the court ordered the prosecutors to respond and said, do you agree with this? Are we really done here? Do you agree that we entered this diversion agreement? Prosecutors respond. They say, all right, judge, we know you ordered us to respond here. Here it is. First, they say government prosecutors did not renege on a previously agreed upon plea agreement, like Hunter's lawyers say, as the defendant, Hunter, inaccurately asserts in his first substantive sentence of his response. Ooh, things are getting a little tense here. They say Hunter chose to plead not guilty at the hearing on July 26th, and U.S. probation, which is the entity that would govern the diversion agreement, they declined to approve the diversion agreement at the hearing. So that immunity deal that Hunter's lawyers say is done, government says no. Thus, neither proposed agreement entered into effect. And this is the only thing that they could say. If they said that there was any other immunity, then that means the special counsel that just got appointed is moot. It's basically nonsense, because even if there was a little immunity, there would be no need for a special counsel. It'd already be a done deal. So the government says instead, as of the end of the hearing on July 26th, the 2 proposed agreements were just drafts, all right, that either party could propose changes to. And both parties did propose changes to it following the hearing. Now, if you remember Hunter's lawyers, they said, no, Hunter's already been living by the terms of this deal. He's already been calling and not doing drugs and staying in accordance with the law and all that. And they say, well, that's nice, but he didn't sign an executed agreement. Without going into the substance of the negotiation, the government prosecutors say, in the afternoon on the day of the hearing, Hunter's lawyers asked to meet with the government. So we did. When we met, Hunter's lawyers proposed changes to both documents. They said, all right, let's change the diversion deal. Let's change the plea deal. The government considered Hunter's lawyers' proposals, but did not believe they were in the best interests of the United States because they got busted, right? If Hunter's lawyers are saying, let's hard encode this immunity, hard encode it. And the government says, we can't because the judge just busted us. We tried to do that. The judge literally just called us out on our first rigged attempt. So they're saying, let's try to re-rig it. And the government says, we can't now, brother. Like, we just got busted. So we said we could offer counter proposals and we can craft something different, but it's obviously not going to be as broad and immune as it was before because there was a lot of immunity in the gray area of these 2 deals, which is why they drafted them that way. So the lawyers say, we offered counter proposals on July 31st. We gave him an alternative. We said, we'll put this here, but it's not going to be blanket immunity. And during the hearing, the government said the same thing. And they asked Hunter point blank, they say, hey, would you take this plea deal if you are not granted immunity? And he's like, no. And then they took him back in the closet and they said, hey, say yes, you screwed that up. So they brought him back out. She asked him the same question. And he says, yeah, now I'll take it. Hunter rejected these counter proposals on August 7th. Doesn't like the new deal. So the government says, seeing that the parties were at an impasse, the government informed Hunter in writing on August 9th that it was withdrawing the most recent version of its proposed plea and diversion agreement. So this makes what those defense attorneys did even scammier. It's incredible what Hunter's lawyers have done. They told the judge that the deal was already done, even though they got notice that the deals had been revoked. They said, hey, judge, it's already done. The judge is going to be furious about this, I'm sure. That is why the government has asked the court to vacate its briefing order and to dismiss the criminal tax information. Hunter's lawyers didn't even address that because they say the diversion deal already granted immunity. So the prosecutors continue. They say, second, Hunter makes the factual assertion that the government drafted much of the proposed agreements. And we saw that when we covered their filing. They said, we didn't even draft this. Assuming for the sake of argument that is even true, prosecutors say who drafted the language is irrelevant. Doesn't matter. It's the language itself that controls. And third, while Hunter claims that he was prepared to plead guilty to the charges on the tax information, his answers to the court's questions demonstrate otherwise. At the hearing on July 26, the government summarized the proposed plea deal. At the end of the government summary, the court sought to ensure that Hunter's plea did not, quote, result from promises other than contained in the plea, which is required under the federal rules. The court asked Hunter, addressing him personally like the rule requires. The judge said specifically, Mr. Biden, does the written agreement as summarized by Mr. Wise accurately reflect the agreement you've reached with the government? Hunter says, yes, Your Honor. The court then asks Hunter, has anyone threatened you or forced you into entering this written agreement? Hunter says, no, Your Honor. Has anyone made you any promises that are not contained in this written agreement? Before the defendant could answer, Hunter's lawyer, Mr. Clark, interrupted and prevented the defendant from responding to the court's question, because they did. Has anyone made you any promises that are not contained in the agreement? Okay, they asked that so that they protect against the backroom deals. They obviously did promise him a bunch of stuff. The government promised them there's not going to be anything coming. Hunter was going to answer that question wrong, and so the defense attorney jumped in. Here's how it went. Defense attorney says, Your Honor, with the exception of the diversion agreement. Judge says, we're not making an exception. I want to know right now, has anyone, Hunter, made you any promises that are not contained in the written memo of the plea? Because the judge is going to say if they did, they're not valid, right? They're outside of the terms. So you better tell me now. If you think there are, they're not. And she's asking Hunter, has anyone made you, Hunter? The attorney says, yes, Your Honor. There are promises from the government in the diversion agreement, the separate document. She says, okay. And sir, Hunter, are you relying on the promises made in the diversion agreement in connection with the agreement to plead guilty on this other case? Hunter, yes, Your Honor. I am relying on those promises. Hunter, if that separate agreement, which contains those promises, were not valid or unenforceable for any reason, would you enter into this agreement? No, Your Honor, I wouldn't. At that point, the government says the court, by the plain terms of Rule 11, could not accept a guilty plea as knowing and voluntary. The rule says, ensuring that a plea is voluntary, you got to go through these rules. And at that point, Mr. Clark and his client were both telling the court that Hunter was pleading guilty because of promises that were not contained in the plea. This was a problem entirely of their own making, and not one that resulted from the drafting of the proposed plea or diversion. The final paragraph of the proposed plea agreement, in paragraph 13, expressly states, it is further agreed by the parties that this memo and Exhibit 1, along with Attachment A, supersedes all prior promises, and that this memo may be modified only in writing by all parties, and that any and all promises, representations, statements made prior to or after this memo are null and void and have no effect whatsoever unless they comport with the subsequent written modification of this paragraph. So the government says, look, Judge, the plain meaning of this text is that the parties are not relying on promises outside of the four corners of the proposed plea agreement, the four corners of the page. Obviously, the proposed plea agreement did not contain paragraph 15 from the diversion, which was the immunity paragraph or anything like it. Therefore, it was not a promise contained within the proposed plea agreement. And fourth, Hunter asserts that his understanding of the scope of immunity that was agreed to by the United States was and is based on the expressed written terms of the diversion agreement. He then asserts that his, quote, understanding is corroborated by prosecutors, by their contemporaneous written and oral communications during the plea negotiation. He says they were negotiations. We're allowed to have statements like that. That's why they're called negotiations. Without conceding that the latter is true, he says it's irrelevant. The very last paragraphs of the now withdrawn plea and the diversion agreements state that the agreements supersede any prior conversations. So if they want to reference my prior statements, it doesn't matter. This supersedes all of it. And that this is now the complete term of the agreement and no other agreements. What both now withdrawn agreements expressly stated, so he says they are withdrawn, was that it was the agreement themselves and not the written and oral communications during the plea negotiations that dictated the scope. And fifth, the government says, as noted above, the proposed diversion agreement never took effect. And Hunter misstates the record when he claims that the government made statements to the contrary. Hunter claims in a footnote that the government stated in open court that the diversion agreement was a bilateral agreement between the parties that stands alone and that it was in effect and binding. But those cobbled together snippets did not add up to a statement that the proposed diversion agreement was in effect. The government never said the proposed diversion agreement was in effect because it is not. And in none of the portions of the transcript that Hunter's lawyer cites in this footnote did the government say that the diversion agreement was in fact in effect. In fact, the government said the opposite. In response to a question from the court, the government explained how the diversion agreement worked as follows. Prosecutors said at the hearing, I think practically how this would work, Your Honor, is if Your Honor takes the plea, if you take it, and signs the diversion agreement, which is what puts it in force as of today, and at some point in the future we were to bring charges and the defendant thought that they were encompassed by the factual factual statement in this agreement, they could move to dismiss those charges on the grounds that we had contractually agreed not to bring the charges that are covered here. They cite a footnote. They say Hunter's citations are also misleading. That's where I was going with this. I think they're being dishonest to the court. Hunter's lawyers never mentioned any of this to the court. They never mentioned that there was a revocation of the plea or the diversion deal. They're lying to the court by omission. Hunter states that the government stated in open court that the diversion agreement was in effect. The only time the government used the words in effect were in response to a hypothetical. The court, his lawyers are just very shady, very dishonest, and the judge is probably going to blast them on this. The court question was premised on a hypothetical situation, and they just pulled it out of their own. Typical figures. They say the government's statement that the agreement goes into effect if the court signs it is a recognition that the signature of the probation officer was necessary to put the agreement into effect. Miss Bray is the head of an office within the court and would be acting at the court's direction, as was made clear in the hearing, when Miss Bray declined to sign and approve the agreement. Yeah, they say, to reiterate, government prosecutors say Hunter Biden, the now withdrawn diversion agreement by its own terms is not in effect. Sorry, Hunter, no immunity from the government. Paragraph 1 of the agreement expressly provides that the term of this agreement shall be 24 months beginning on the date of approval of this agreement, unless there is a breach. Paragraph 2 further provides it requires approval. Miss Bray, the probation officer, declined to approve the agreement at the hearing. The version of the agreement that Hunter docketed has an empty signature line for Mrs. Bray. So even though Hunter signed it, Miss Bray didn't. She didn't approve it. Immediately below the text of approved by. In some, they say Miss Bray, acting in her capacity as the chief probation officer, did not approve the now withdrawn diversion agreement. It never went into effect, and therefore none of its terms are binding on either party. This is so messed up. I mean, this is so botched. It's unbelievable. The government created this whole deal. Then they tried to enter it. Then the judge rejected it. It's so botched now that Hunter's team is claiming immunity, and the government is having to backpedal and defend against their own deal that they started to enact. It's crazy. It's like Bizarro land. And the only reason that they're now having to backpedal is because the judge busted them, and they have to save face. What happens if this judge comes back and says, sorry, Hunter's immune? You guys signed the deal. I mean, the law says it. She's not going to do that, but she could. And Hunter's lawyers could be victorious. And it would be because the DOJ either wanted this to happen or they intentionally botched it. I mean, they are total incompetent. They are now defending, backpedaling to defend not entering a deal that they created themselves, that they tried to cram through. Now they have to say, no, we didn't intend to do that. It's like a joke. All right. So similarly, the deals have not gone into effect. The government's letter to the court in August, which stated the government's position should be docketed. It did not state that either agreement had entered into effect because the agreements had not gone into effect. Respectfully submitted by David Weiss, special counsel, actually written and signed by Leo Wise, who was the actual prosecutor who was there at the time. So the government is backpedaling big time to try to fix what they've already done. And the judge wants an update on this. So has said that Hunter and his people need to respond to the filing. And we've got nothing too new here on the court docket. So the judge is going to want a brief on this from the defense, and she'll issue a ruling. Of course, we'll continue to follow. But the media is now saying Hunter Biden is under attack. This is just the Republicans investigating a private citizen. Forget about the IRS whistleblowers. Forget about the text from Hunter saying he's sitting right next to daddy. Forget all the dinners, all of the golf outings, all of the speakerphone phone calls, all of that stuff. No, no, no. Hunter is just an innocent person who is being attacked by those evil Republicans.
Congress needs to stop investigating a private citizen and stop this fishing expedition to try to link President Biden to Hunter Biden's conduct.
Hunter Biden's being subjected here to a level of not only scrutiny, but accountability that most mere mortals would not.
Hunter Biden, he could be a terrible guy. I don't know, never met him, is being treated worse than anyone else would be.
This is the son of the president. He's not the candidate. He's not a political officer. Doesn't even begin to compare to classified documents and to the indictment here in D.C.
It's just the standard talking points. They got the memo. Protect old Hunty. Just an innocent guy, you know, and those Republicans are just picking on President Biden's son. Ted Cruz has some reaction to this, calls it all political. Don't forget to subscribe to his podcast, okay?
The timing is nakedly political. Every time more bad news comes out about Hunter Biden or Joe Biden, you can set a stopwatch within hours. Some clown goes and indicts Donald Trump again. And then all of the little lemmings in the media go run and say Trump, 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 Trump. Look, last week, the House Oversight Committee released bank records that showed that Joe Biden's family and associates received over $20 million from foreign sources while Joe Biden was vice president. So just when he's in office, over $20 million. Let me ask you, is there anything on earth, Sean, that Hunter Biden could do for you that would be worth $20 million? Well, if you're a Ukrainian oligarch or a Russian oligarch, I guess so. And if you actually go just after the vice presidency, Hunter and his family got another $8 million from the Chinese communists. You know what just happened last week? Last week, the statute of limitations ran on the $8 million that flooded to the Biden family from the Chinese communists. You know who let it run? David Weiss, the U.S. attorney who is obstructing justice, who is blocking an investigation.
Amazing.
And what did Merrick Garland do? He named him a special counsel, which is disgraceful. As you know, I do a podcast every week, Verdict with Ted Cruz. Today's podcast goes through why David Weiss's appointment is illegal. It is directly contrary to DOJ guidelines that say that it has to be someone outside of the Department of Justice. Merrick Garland doesn't care. He's ignoring the law. But more importantly, it's supposed to be someone with integrity to prosecute. And David Weiss has shown that he's willing to block prosecution of Hunter, to allow the statute of limitations to go forward, and to allow apparatchiks on his staff to protect Joe Biden, to say no questions about the big guy, no questions about Joe Biden. It's why you've seen two senior IRS career whistleblowers come forward, and it's why I believe we're seeing an indictment likely tonight, because the media wants to change the topic.
Yeah, and they want David Weiss just reappointed so he can continue this giant scam. I mean, he's already been pretty good at keeping Hunter Biden out of real serious criminal trouble for the last 5 years or so. So what's another 5 years? We'll just make him special counsel. It's like, hey, yeah, just appoint this guy. And the media, they say that Hunter's under attack when really we know that almost nothing has happened to the Bidens at all. The real people they're attacking is Donald Trump. And as per usual, when they're doing something like prosecuting and attacking their political opponents, the standard tactics from the Democrats, of course, we'll continue to cover. Things are going to get spicy in this Hunter battle. I think the judge is going to be furious that the defense tried to pull one over on him. Of course, we'll see what it looks like as we continue to cover. Thank you for subscribing, my friends, and following along as we do. We'll look forward to seeing you on the next one.